The parties are about to enter into compromise, so I may be allowed to withdraw. That is what I like to submit.
Which matter?
Part 2, item 8.
I have the list. You want to withdraw the matter?
Yes, my lord.
Yes. It's an appeal. I see.
Yes, my lord. FAO,
So,
my lord.
no problem. Learned counsel submits that he has instructions to seek withdrawal of this appeal. Full stop. The prayer is allowed, and accordingly the instant appeal stands disposed of upon withdrawal. Okay?
Deeply obliged, my lord.
May I seek your lordship indulgence in mentioning part 2, item number 7, lordship. I have taken the consent, so the matter can be taken up after 2 weeks, lordship. Deeply obliged.
Item 7,
Yes, lordship.
after 2 weeks.
It's part 2, item 2, my lords. It is fixed for today. I understand your lordship is leaving. My lords, if it may be fixed for 7th of April, my lords.
Specific date
Yes, my lords.
No, my
Why,
lord.
my lords? Because the appeal has been pending for some time.
for some time. I don't have the list. Can you give me the list?
Even
please?
in the last order, my lords, we had
Okay.
objected to the adjournments.
Today, of course, I have some constraints. So,
Yes, my lords.
what about, ma'am? You want to say
My
something?
lords, if I may, my senior will be out of station for this
Okay.
month, my lord. So if it may be taken up on the second week of April without.
Second week of April.
Yes,
My lord,
my lord,
7th
and
is
will
second
be-
week of April, my lords. 7th of April.
That will be an interpretation. Anyway, so I don't have any problem. Mutually convenient. You work it out. Let me know.
Yes, yes, my lords. My lords, let it be listed in that week then, my lords.
I say that it will be in the first week of April.
My lord,
Your senior has difficulty in the first week of April.
yes, my lord. If it may be, if
Second
it may
week
be
of-
listed on the second week, my lord, without
Second
a
week of
fixed date. if
April on a
possible.
date to be fixed by registry.
Yes,
And
Keep
my
it
lord.
like
lords- Yes, my lords.
My
And no more further adjournments, my lords.
The second week of April on a date to be fixed by registry. Full stop. The learned counsel for the appellant submits that the matter is pending for some time and seeks expeditious adjudication. So,
Deeply grateful.
yes,
Yes, my lord, may I seek your lordship indulgence in mentioning part 3, part 2, item number 3. Yes,
no, never mind. Part 2 matter, item.
item number 3.
Another date.
If it may be listed on this coming next week.
Adjourn for today and list next week. You want a date? Let it be fixed by registry. Okay? Let it be fixed.
It's upon the registry.
Registry. On a date to be fixed by registry. Item, it was number
3.
3. You've taken down correctly.
Orders, item 1.
My lord, this is a bail application in POCSO
Yes.
matter. And I have given a notice to the informant, my lord. I have given a copy.
Okay. Service is complete.
Service is complete, my lord.
Okay. You want me to see that?
I've given a copy.
It's at the stage of this. Okay. Trial is going on, right?
Yes,
Trial is going on.
yes, my lord. Trial has commenced, my lord.
Trial is commenced. The victim has been examined. Has the victim been examined? So we'll go into the
My lord,
submissions.
I'll have to get instructions regarding the...
Scan copy was called for, I guess, right?
My lord, I don't think we have called any because we have given only notice to the informant.
What's up?
And
No,
since
it could
he
have
cannot
called
be
actually. It
served.
would have saved some time. Anyway, he has annexed many documents, but it's not. I could not. I might have missed, but not clear whether it is. You're not sure, no? Whether victim is examined or not. Victim is
Not sure,
examined.
my lord.
Not sure.
But since, my lord, there are as many as 10 witnesses to be examined,
Yes, yes.
the petitioner, my humble prayer is to maybe release on bail. because the trial will take time, my lord.
My lord, since it's a POCSO matter, do we need to appoint legal aid counsel in?
Yes, that we have to do. Mrs. Linda Alfam, learned public prosecutor for the state, submitting the relevant document before the court, indicating that service upon respondent number 2 informant is complete. First, as none has appeared on behalf of the informant. You can suggest whom should I appoint? Anyone here? Would you? Anyone? You can.
Jonathan is here, my lord. I think he can be appointed.
Please. He's appointed as Mr. Jonathan is appointed as legal aid counsel to represent the informant. Right. First, the learned counsel, Mr.
Not legally, amicus.
Amicus. Amicus. Full stop. He shall be furnished with a copy of the petition. Mr. Khyangte, learned counsel for the petitioner, submits that there are 10 witnesses and the petitioner has been in under trial detention since September, right?
My lord.
September 2025. So let us, you kindly furnish him a copy.
My lord.
And we have to call for the scan copy, I believe, isn't it? Call for the scanned TCR comprising case diary, charge sheet and other relevant documents from the court of the learned, which is from the special judge POCSO Aizawl, I guess, right?
My
Special-
lord.
Yes,
My lord, it was before the fast track court.
fast track court is. Special judge POCSO, fast track. We can have it next week.
Next week, my lord.
This is the matter. We can fix a date if you want. Thursday we can fix it.
11, my lord.
My lord, 11 I have some.
11 DB might also be there. I think we fix some matters.
10, my lord.
Take it on. 11th is Wednesday.
Yes, Tuesday.
Thursday, my lord, 12.
Thursday will be best, I think. 12/3.
Obliged, my lord.
This I can keep. Yeah.
Yes, my lord.
12/3.
Item number 2.
Yes, Jonathan.
This is an application for bail. The accused was arrested in connection with Section 21C of the NDNPS Act.
Notice issues there. Some
Notice has been issued and TCR has been called for. Scanned copies of the TCR.
No, you are contending about grounds of arrest?
Yes, Your Lordship.
Yes, ma'am. Yes.
Yes, Your Lordship, we can proceed. We have received the scan copy. The scan copy is here, and we have perused the scan copy as well. And Your Lordship, in the scan copy, there is a Caesarean arrest memo. CRPC, which corresponds to Section 47 and 48B NSS, and Article 22(1) of the Constitution, that it is incumbent on the part of the enforcement agency to inform the accused the grounds of his arrest In the present case, though the grounds of arrest has not been put down in writing in the notice under Section 50 CRPC and the arrest memo dated 2011-2022, the petitioner has been produced before the court on 2011-2022 itself. In the present case, Your Lordship, the petitioner was produced before the magistrate on 14, the next day. The petitioner had, wherein the police had prayed for custodial interrogation of the petitioner. The application for remanding the petitioner to police custody clearly provides the grounds of arrest of the petitioner and the reason for the arrest. The very fact that the petitioner had allegedly concealed the alleged article on his body with a brown tape implies that the petitioner was aware of the contraband that he was carrying. As such, the reverse burden of proof under Section 35 NDPS Act would require the petitioner to prove that he was innocent of any wrongdoing. The above being said, as he has been observed in the Supreme Court Justice Madhu Limai, which regard the House of Lords case in Christie versus so-and-so, there is no need to explain the reason of arrest if the arrest man is caught red-handed and the crime is patent to high heaven. In any event, the arrest of the petitioner has been made on 19/11/2022. This is the important relevant part, Your Lordship. Prior to the judgment of the Supreme Court in Pankaj Bansal, as the Supreme Court in Pankaj Bansal has held the henceforth, the ground of arrest must be communicated in writing to the accused. The same would be applicable only after the said decision was made. Thus, the effect of non-writing down the grounds of arrest in the present case, in the view of this court, cannot be a ground to release the petitioner on bail. So, Your Lordship, this is very
But,
clear. That
but the subsequent decisions of Vihan Kumar and Purkashto and Mihir Shah, they do not indicate that it is retrospective only. It is prospective only.
yes, Your Lordship, but
That therefore, in the absence of more clarity on that point, we have been applying it retrospectively
exactly.
also. That is
But
why.
however, in this
But
case,
there is an observation in one case in the, of the Supreme Court that how far back you can turn the clock in one serious matter. But beyond that, they did not say anything.
exactly.
Anyway,
And however, I rely on this judgment and order, Your Lordship. And here in this judgment and order, it is clearly stated that the arrest was made prior to the judgment and order, which the petitioner has relied on. So my objection is that one, Your Lordship.
anyway, so have you annexed the grounds of arrest, the notice, 47 notice? Have you annexed?
Your Lordship, there is no notice. That
There's
is
no
the-
notice.
Yes, Your Lordship.
Seizure and arrest memo is
Okay,
there.
I'll see that, ma'am.
That one.
No specific notice under 47, 48.
Yes, Your Lordship.
47, 48 also, no? No notice.
No, there is
No
no
notice.
notice. Only arrest
Specifically
memo.
informed, there is no.
His relatives were also not informed.
So,
At page 20
on the face of it,
the-
informed, the notice is not there, but on the basis of the prosecution submission, we have to see whether there is substantial compliance.
Yes.
That we have to see.
Yes.
Can I have a look at that? Scan copies. Just a minute. He was arrested in August 2023.
23.
And what is the stage of the trial? Do you
It
have
is
the
at the
feedback?
stage of defense evidence, Your Lordship.
Oh, sorry, we have already discussed about received information.
And Your Lordship, in page number 20 of the application, that is seizure and arrest memo. Here,
They have
all the
annexed.
seized article has been written down clearly, and the signature is also given by the accused, by the petitioner.
This is the one? This is the one?
Yes, Your Lordship.
Your Lordship,
Yes.
if I may, there has to be a stark distinction between arrest memo and intimation of grounds of arrest to the accused also. And regarding the time of arrest, concurrent bench of this Honorable Court has decided in bail application number 39 of 2025, which was decided on 25/9/2025. And it has stated that while relying on the judgment of the Apex Court, it has stated that held that the judgment of the court will always be retrospective in nature, unless the judgment itself specifically states that the judgment will
Always be retrospective.
retrospective in nature. I have placed the
It's
citation
there.
also.
Yeah.
Basit Udin
Okay, give me that.
versus State of Mizoram. At page 14 of the said judgment.
Some circumstances of the seizure has been mentioned here, but these are not grounds of arrest,
Yes, Your
actually,
Lordship.
strictly speaking. Anyway,
And in this 313
you have
examination.
also annexed, this one not very legible. You have also annexed this one? Seizure?
Yes, Your Lordship.
Page number?
Page 20.
20,
Yes, Your Lordship.
20. At that time, even the police did not know, and the excise people did not know even more at that time. 23, anyway. So.
In the case which I had mentioned, Your Lordship, the arrest was also made on 23/1 of 2023. And in our case, it is 13/8/2023. So much earlier than that, the concurrent bench of this court had also allowed bail on the ground that grounds of arrest were not furnished to the accused.
These judgments you have submitted?
Yes, Your Lordship.
What is this Kanishk Sinha? This though I know.
Basit Udin,
Inform
the
Broadcaster though I know. And the decision you just mentioned is this one?
yes, no, that is Vihan Kumar. The one is this one. The
Let's have a look.
okay, Guwahati High Court.
No, the retrospective
Retrospective one. That is at page 14 of the judgment, Your Lordship.
Can you have, just share it with me.
Page 14, if I may read, Your Lordship.
You can take from the previous order, okay? Let's start. You can take from the previous order. Previous order, you take first paragraph, third paragraph, and the second last paragraph. Full stop. The case arose out of an FIR dated 13/8/2023 with the allegations that upon information about possession of suspected contraband substances, an operation was carried out, and thereafter 1,216 grams of suspected heroin were recovered from a room rented by the accused persons. Full stop. Upon completion of investigation, a charge sheet was submitted, and as mentioned above, the case is at an advanced stage of the trial, where only defense witnesses, if any, remain to be examined. The primary contention, as mentioned, is that the notices under section 50/50A CRPC, within bracket, as it existed then, within bracket, bracket close, were not furnished to the petitioner at the time of his arrest. Or at the time of his arrest on, he was arrested on
13/8.
same date, 13/8/2023. It is submitted that ever since his arrest, he has been under trial detention and presently in judicial custody. Full stop. The learned counsel for the petitioner relies upon the following decisions. I'm just writing P. Full stop. The scan record has been received. Full stop. Mrs. Vanessa Ami, learned additional PP, submits that fairly submits that though specific notices have not been found in the record, but in the Caesar list, in the Caesar memo, Caesar cum arrest memo,
Yes.
Caesar cum arrest memo, there is narration regarding the circumstances in which the petitioner has been arrested. A copy of the same has been annexed by the petitioner and also available in the scan record, and I have perused the same. The Caesar cum arrest memo, actually it should be separate anyway. Caesar cum arrest memo indicates the name of the arrested persons, semicolon, particulars of the seized materials, and particulars of the seized materials. Can I have that decision that you have?
Yes, Your Lordship. The order is
In support of our contentions,
order dated 24/6/2025.
in support of our contentions, the learned additional PP refers to the decision of this court in so and so and submits that. Considering the circumstances of their arrest, the petitioner was fully aware of the grounds of arrest. In probable, full stop. In probable, I have considered the material, I have perused the materials and considered the submissions. Full stop. In probable procasta, supra, it was held that grounds of arrest in reasonable detail and specific to the person, arrested person, should be furnished, and that the same is necessary in keeping with the mandate, constitutional mandate under Article 22 within bracket 1. In Basituddin Supra, this court basically went into the applicability of these directions given by the Supreme Court regarding furnishing of notices at the time of arrest, and issued certain directives in para 16 which may be reproduced here in the that judgment, can you give me that? That one.
Which
one? That retrospective.
Your Lordship, that is at page 14 of that Basituddin. It is mentioned in a citation was relied upon, Kanish Sinha.
Page 14.
Yes, Your Lordship. I have also provided...
Kanik Sinha.
Kanish Sinha. I have also provided the full text.
Referring to Kanik Sinha within that Supra, the learned counsel for the petitioner submits that unless stated otherwise, the judgments of the courts of records would be retrospective. This judgment I have to locate it
Yes,
and I have to
I will produce.
produce. Because I have to see that judgment. I'll dictate in the chamber. One more matter is there. Give it in the chamber. Remaining in the chamber. Remaining, I'll give it in the chamber. This much you can type.
Item number 2.
Your Lordship.
You can,
May it pleases your lordship.
you can send him perhaps. You can type. You can start this typing and send Bonachit. Right? Yeah, save us time. Yes.
May it pleases your lordship. My lord, am I audible, my lord?
Yes, you are audible. Yes.
My lord, here my basic ground your lordship will find at page 18 and 19, 1, 8 and 1, 9 of
Okay.
my bail petition.
In
My lord,
paragraph,
these are the
page 18 and 19.
19. My lord, whether this would suffice the condition laid down in Article 22 and for that matter those long barrage of judgments starting from Pankaj Bansal, Praveer Prukaisto and all those, my lord. In my respectful submission, my lord, this intimation of arrest cannot be construed to be an intimation of grounds of arrest. This is one. Second, the 48 notices which were sent to us, which your lordship will find at page number 20 and 21. I have two submissions with regard to page 20 and 21. Number one, my first submission is that these are not the signatures of the family members of the arrested accused person. Assuming that this has been served, that's my second limb of argument, these are in a language which is not understandable by the accused petitioners or their family members, because the accused petitioners, they understand English or for that matter, Kuki language, because they belong to the Kuki tribe in the state of Manipur. Whereas, my lord, these 48 notices were served in Mizo language. My lord, I don't think, my lord, I'll have to take your lordship to those plethora of judgments. Your lordship is well aware, my lord. I'll not bother your lordship with any
All
such
learning.
judgment.
Anyway, man.
In
Record we had called for the record, right? This also. Scan record we had called for. This was an arrest in 2023 also, right? 2020. No.
No, this is
No.
25.
This is recent, my lord.
2025.
I see.
2025, very recent.
And it should have been.
And Your Lordship, in this
No.
regard, what I would like to mention is that the counsel for the appellant, his main grounds is that the notice given under Section 47 is not in a detailed form. And as we peruse these grounds of arrest under Section 47 BNSS produced to him, it is written, clearly written that he has been arrested under Section 21C 2000 Indian PS Act. And Your Lordship, in this regard, what I would like to submit, and I would like to rely on that citation, Vihan Kumar, that is in conclusion part, paragraph 21, subclause B. It is written clearly that, if I may read out, Your Lordship,
Yes.
Vihan Kumar,
Para 21.
para 21, subclause B.
Please.
The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode and method of communication must be such that the object of the constitutional safeguard is achieved. And Your Lordship, what I would like to submit again is that under Section 21, there is no mode. There is no mandate mode. That it only stated that the accused must have aware on what grounds they have been arrested. So there is no specific mode. And in that case, Your Lordship, the arrest memo which he was served upon him, there is a substantial compliance of the Constitution. And another citation which I would like to rely is
Yeah.
My lord, may I-
2025.
Yeah, I'll come to you, just a minute.
2025 SCC online SC 1228.
Kasi Reddy.
Kasiredi. Para number 27. Your Lordship. If I may read out.
Yeah.
The object underlying the provision that the grounds of arrest should be communicated to the person arrested has been very succinctly explained in Vihan Kumar. On learning about the grounds for arrest, the person concerned will be in a position to make an application before the appropriate court for bail or move the High Court for a writ of habeas corpus. Further, the information will enable the arrested person to prepare his defense in time for the purposes of his trial. For this reason, it has been provided by the Constitution that the grounds for the arrest must be communicated to the person arrested as soon as possible. So, Your Lordship, it can be seen clearly that he has been arrested on 2025 in the month of November. And now we are in the month of March, and the application has been submitted by the applicant in the month of February. So it is clear that he is well aware on what grounds he has been arrested. So the purpose have been complied with, Your Lordship.
Anyway, so
My lord, I'd just like to indicate one order of this honorable court. My friend Emmanuel is there. He will give he'll supply a hard copy of that order. BA 49/2025, bail application 49/2025. It is the same police station, that is this present police station, Saithol police station, and the similar nature of ground of arrest. I mean, if I may call it, it may be at best be called as an intimation of arrest, not a ground of arrest. Same. It's there, my lord. B number 49/25. My lord is there.
yeah. Para?
My lord, para 10. My lord, may kindly come to para 10 and compare this para 10 with the present ground of arrest section 47 notice. Ditto same.
This was the format. I mean, at this stage, in November 2025, the
Yes.
proper format should be followed, because now
Absolutely.
our learning window has almost gone now. It's still there. We are always there learning, but now, because these are serious matters actually. Anyway, so whatever it is. Investigation is going on, man.
Yes, charge sheet has not been submitted yet. Now the investigation is going on.
He is in custody for more than 100 days, my
And
lord.
Your Lordship, my another grounds is that if he is released on bail at this stage, there is a highly chance of absconding as well as hampering the investigation. And moreover, Your Lordship, the petitioner is not a resident of Mizoram. So the investigation can be hampered.
That can be assured by adequate sureties, my lord, because, my lord, geographical barrier cannot be, my lord, a ground for denial of
Police have been
bail.
trained. I think they will need further training, because what concerns me is that in November, these are serious matters. In November, there should not be technicalities should be followed. Anyway,
And another thing, what I would like to submit here is that, Your Lordship, the seizure was made inside the vehicle driven by the petitioner, and there are two applicants in this case. So both of them were sitting inside the car, and they were intercepted in the checkpost, and it was recovered inside their vehicle. So it is very clear that there has conscious possession, and the embargo of Section 37 is strictly attracted, Your Lordship.
250 is the this commercial above 250 grams. So
This
now
is a
it's
commercial quantity.
it's huge amount.
No, it's Iman Asile?
No, sorry.
1126 gram, 1126.97 gram.
Anyway, so all right. That's the order. So, okay. Anything from your side?
No, my lord, one or two more judgments were there, my lord. If required, my friend will just give it for
Yeah.
record. Otherwise, your lordship is aware, my lord, I don't need to press. I am deeply obliged, my lord.
We are all learning.
Absolutely, my lord.
Just put it, huh? Just staple it kindly. That's well. Anything else? No? You have something? Finish these two orders.
I understand the urgency that
No, I have time.
I have one fixed item in the hearing, item number 4. It can be disposed of in one line only, my lord. It's a contempt matter, my lord.
Yes.
The judgment has been complied with, so it can be disposed of. The contempt matter can be closed. Item number 4 of part 2. The matter pertains to challenging the illegal absorption of the private respondent in the writ petition. And I have furnished the compliance order, my lord.
You are for the petitioner?
I am for the petitioners, my lord. My writ petition was dismissed and I have preferred writ appeal, where
In the meantime, they have
my appeal was
complied.
allowed.
Should I pass the order or should I keep it for tomorrow or something?
The order which I am referring, my lord, A and B, I have marked it. By this notification A, they have created a supernumerary post of lecturer. And by this notification B, they have posted the private respondent in the writ petition to the post of lecturer. Earlier, he was posted to the post of principal, which we have challenged. And in compliance with the order of this court, my lord, they have now posted to the post of lecturer. So, the judgment of this honorable court has been complied with and the contempt can be closed.
Ma'am, you are appearing?
However, I think they have a,
Let it be closed,
yes, I think it can be
It
closed.
should be closed. Mr. Learned Counsel appearing for the petitioners. The respondents are being represented by Mary Alcantara. All the respondents?
All the
All the
respondents.
respondents.
You are for all the petitioners, right?
Yes, my lord.
All the 4 respondents / contemners are represented by Learned Counsel, represented in this case by Mary Alcantara, Learned Counsel. Yeah. She is additional government.
My lord, in this, she's appearing as a private counsel.
Private counsel, learned counsel. So the instant contempt proceeding was initiated by the petitioners, alleging non-compliance and disobedience with regard to judgment and order dated 13/11. Just correct me.
Yes, my lord.
13/11/2024 in WA number 6/2023. Should I go into the detailed narration or it's
No, my lord.
not necessary?
No, my lord.
Full stop.
Not necessary.
Learned Counsel for the petitioner submits that in the meantime, the petitioner, the respondents have complied with the direction given in the aforesaid judgment. And in support of the same, he submits a notification of the Government of Mizoram School Education Department dated 23/2026. It is submitted that the petitioner appellant, the writ petitioner who had filed the writ appellant, has been absorbed as a lecturer.
No, my lord. The petitioners were challenging the illegal absorption of the private respondent
I see.
to the post of principal.
I see.
So our contention is that he should be absorbed to the post of lecturer instead of principal. So by this notification, my lord, they have complied with the judgment by posting him to the post of lecturer.
Well, let's not say anything then.
It has been complied with.
Full stop.
That will
It has been
suffice.
complied. It is submitted that in view of the compliance with the judgment and order dated 13/11/24, passed by this court, by division bench of this court in WA 6 of 2023. Perhaps the contempt petition can be closed. It's well settled that after disobedience of the court's order is pointed out by the petitioner, the matter of contempt, if any, is essentially between the court and the alleged contemner, and that the contempt jurisdiction is not really for the purpose of execution of the orders of this court. Not really for execution of the court orders. Nevertheless, the aspect of full compliance with the judgment giving rise to the contempt proceeding also cannot be overlooked. Therefore, in view of the latest developments, I deem it just and proper to close the contempt proceeding. Accordingly, the contempt proceeding is hereby closed and disposed of.
Yes, my lord. And perhaps it would be appropriate to place this notification on record.
This notification, the notification dated 23/2/2026 may be kept as part of the record.
Yes, madam.
Okay, kept in the record. We need not reproduce this. I think. No need. No need.
It may be marked as X and placed on the record as
Yes,
usual.
that we can do. The notification be marked as X and kept in the case record.
These two items left over, my lord. This may be adjourned. Item number 6 and 10.
We'll do it next time. And that's how other matters. Okay. If time permits, I'll come once.
Yes,
Okay?
my lord.
Finish this too.
Oh, okay.